Hey, how are you? Come on in, my name's Jesse. Thank you for coming in to visit us here at EmployerCo. We are a firm, a company, that primarily what we do is we represent employers before the different administrative bodies, such as the California Labor Commissioner's Office, the Federal Department of Labor, Cal-OSHA, the Employment Development Department, the Department of Fair Employment and Housing, and we get involved in some lawsuits as expert witnesses in doing exposure analysis. What does this mean to you? This means that you need to be protected as an employer, and that's partially what we do. As part of the services that we provide here, we also act as human resources consultants for your business. We can do background checks. We do payroll services. We have accounting services here. We have training, mandatory training by the state of California that's required for sexual harassment. We do insurance services. Sometimes employers come to us because they have employees that file workers' compensation cases against them, and the employer does not have workers' comp insurance. That's called uninsured employers. We handle those types of cases for you, and we try to represent you in the best manner possible where it's most cost effective for you. However, our most important and vital lifeline to this business is protecting you and defending you as an employer.
Hello, how you doing? This is Jesus, CEO of EmployerCo and President of our licensed and bonded California insurance group. We do umbrella insurance, workman's comp, commercial insurance, trucker insurance, inland marine, and homeowners insurance. Yes, we do sell EPLI insurance. Yes, to protect your assets and protect yourself from any liability and risks that you take on. No, insurance is very important, especially for you and your employees. As of January 1st, 2023, you are required, even if you work alone, to have workman's comp insurance.
Hi, my name is David Fitzpatrick. I'm president of the Monitoring and Compliance Division of EmployerCo. A monitoring and compliance program is highly recommended in certain industries because of various federal and state regulations. Both the US DOL, California, and various other states mandate that the ultimate benefactor of labor is responsible for the misgrievances and malfeasances that happen down the labor chain. So that is to say that for example, clothing manufacturer is ultimately liable for the minimum wage, overtime, or safety issues that happen in their contractor and subcontractor locations. This is true for janitorial, restaurant, hotel, construction, various other industries. So if you have questions about how a monitoring compliance program can help your company, feel free to give me a call here at EmployerCo.
Hi, my name is Joanna Cepeda. I'm the president of EmployerCo. We offer a vast of services in the administrative proceedings before the Labor Commissioner's Office, Department of Labor, Employment Development Department, and Workers' Comp. I have 21 years of experience working with employers and employment litigation and representation for solely employers. From time to time, you will be meeting with me to discuss your case, and I will be providing you with updates. I will be working with you in gathering all the documentation that we will need to gather for litigation on your case. And again, we have a lot of experience dealing with employment cases. We understand that it's a very critical situation that you're in, and we're here to help. Y recuerden, hablamos español y estamos aquí para sus servicios. Muchas gracias.
Hi, this is Jesse Nettie, Accounting and Financial President for EmployerCo. I've been an accountant for over 20 years, working on various industries, manufacturing, biotechnology, and the healthcare industry as well. My main focus is reorganizing the financial and accounting records for, either mid-sized or small businesses. And, my expertise is definitely putting the financial records in place. Please give us a call if you have any accounting and financial needs. We're happy to assist you in any way possible. And the most important thing here is hablamos español. So, vamos.
You're probably pretty upset. You had an employee who you treated very, very well. In some cases, you probably loaned them money, or in some cases, you paid them for hours that they didn't work. And for some reason or another, now they want to file a complaint against you. So whereas they try to make themselves to be the victim, they're not really the victim. You are the victim in this case. And you're a victim in a number of reasons. Why? Because they are making an accusation against you, against your standards, against your business, and they're trying to take your livelihood away from you. That's one of the reasons that you're here. We're here to protect your livelihood. We're here to make sure that you're going to be okay. We do not appreciate employees going to the labor commissioner's office, going to attorneys' offices, and making up these big, large stories about how horrible of an employer you are. And then who's the one that has to pay? It's you, the one that has to pay. You have to make a decision based on economics. We've had cases where somebody can ask for $250,000 and we end up settling the case for $25,000. There's cases where they've asked for close to $6 million and we settle the case out for $25,000, $27,000, $30,000. You'll see some examples of that. So what we're here for, we're here to protect your interests, not the employees. If you look around the office, all you're going to see is files related to employers. And this document shows you that's sent out from not only the Labor Commissioner's office, but from different administrative agencies. If you take a look at the red part, it says you have the right to a representative present at the hearing. It is not necessary that such representation be an attorney. So therefore, you don't have to have an attorney represent you in most of your cases. I'm going to show you a case now, a company, Not Only Jeans, that was being sued, and his customers were even being sued by the plaintiff, Hilda Lina. The claim calls for a total of $26,946, almost $30,000. Now, if you look at the decision on this particular case, the decision, it says order decision and award by the Labor Commissioner's office. They received zero. If you look at the decision by the Labor Commissioner's office, the order decision and award by the Labor Commissioner's office, they received zero amount of money. And why? Because we were able to litigate the case and prove to the Labor Commissioner's office that this particular plaintiff was not telling the truth. Yes, it took quite a long time to do. This case lasted over 2 years, but it was something that we handled, and it came out perfect. Zero liability. We have another case too. Actually, this is a case in Superior Court. The client contacted us when they were served with the case, and they asked us if we could act on their behalf to make an attempt at settling the case. The difficult part of this case, which was filed on February 9th, 2023, and it's important that we note that date, February 9th, 2023. They were being sued for wrongful termination, retaliation, employment discrimination based on pregnancy, employment discrimination based on disability, hostile work environment, intentional infliction of emotional distress, failure to accommodate, failure to engage, neglect, failure to pay minimum wage, failure to pay overtime, failure to adhere to rest periods and lunch periods. In this particular case, if you notice down towards the bottom of the prayer, what the end of the case is, they're asking for a total of $5,985,000. We got involved in this case. We settled this case on April 25th of 2023 for a total of $27,500. That's a big difference from $6 million. The last case that we have as an example is from the Labor Commissioners also. This involved a company and an individual by the name of Luis Mijangos. The reason I'm giving you these names and showing you these documents is all public record. They were being sued in excess of $210,000, excuse me. We ended up litigating the case, and again, it took us 2 years. But if you look at the document and the resolution of this case, it ended up at zero. Now, can you imagine an employee with witnesses suing the employer for $210,000 and there being a zero liability? That was the order and decision from the Labor Commissioner's office. This is what we did for this client. At some point, you're probably going to ask yourself, how does he do it? How do I do it? It's all the experience I have. I've been doing this for 37 years. I was an investigator, a criminal investigator for the Labor Commissioner's office. Most of the programs that they're using now, I'm the author of those programs. So when they try to pull one over on me, they're not going to be able to do it. Why? Simply because I understand the system, I understand the way it works. And we're going to fight for you. We're not going to let it go. When I feel that you're right, we are not going to let it go. And we're going to try to get what you want. But we have to be realistic. Sometimes we can't do it. And it doesn't take research. It doesn't take a whole lot of time to figure out where you're at. When you come and meet with us, probably within the hour, I'll be able to tell you where you're at on your case. Without any promises, we can gauge what's going to happen.